$2.7 trillion of social impact investing money that's available for these companies in the market today, and about 200,000 self-identified sustainable businesses. Now, that's a huge potential market, but we found that it's actually being constrained by current corporate law. So to solve this problem, we worked with Drinker, Biddle, and Reef to create the benefit corporation model. And I'm going to let the lawyers talk about the details of that model, but just to kind of give you a very, very brief synopsis, is it's a voluntary corporate form that allows directors to hold their companies accountable to higher standards of purpose, accountability, and transparency. As of right now, there are about 550 benefit corporations around the country. This is an estimate because not all secretaries of state actually track the number of benefit corporations. As you can see, there are some incredibly well-known companies that have become benefit corporations. Patagonia, the clothing company in California. Plum Organics, which is a baby food company, also based in California. Greyston Bakery, which is actually up in Yonkers. They make the brownies for Ben & Jerry's ice cream. And Method Products, anybody who's been to a Target who knows what Method is. And there are also some more traditional companies. Solberg Manufacturing, based in Illinois, is a manufacturing company that produces vacuum filters. And they chose to become a benefit corporation because this is the ultimate expression of their business philosophy. This is the way that they're going to be able to bring on outside investors while protecting their mission. The legislation so far, this map is slightly out of date. We actually have passed in 23 states right now. 3 states since the beginning of 2014. And in the last week, 2 states have actually been signed by the governor. West Virginia and Utah were just signed yesterday and the day before. And we're waiting on the signature in Nebraska. We're moving forward in about 12 states this legislative session, and I'm hoping to hear really good news in the next couple of weeks from New Hampshire and Florida. So just as an FYI, if you guys want to learn more, this is kind of the clearinghouse of information for all things Benefit Corp. It's www.benefitcorp.net. There's tons of information there, how to become a benefit corporation, what it means for a business, what are your liabilities, information for attorneys, and things like that. So, short and sweet, there's my contact information.
Great. Well, why don't we hear from the other panelists, and then we can, I'm sure, get a dialogue going. So, Alan, take it away.
Sure. Thank you. I'm Alan Bromberger, and I'm a practicing lawyer in New York City. My practice focuses almost exclusively on social entrepreneurs and businesses that are sort of non-traditional or looking to combine both financial and social goals at the same time. And if we can get that slide up there, we're looking for it. It's an illustration of what.
Can you give me your memory stick again? Sorry.
Yeah, it doesn't really. Maybe. Anyway, really the important point to make here is the fact that when you look at sort of, when I went to law school, there was no, there was sort of, if you wanted to go into business, you would be a corporation or you would be a partnership, and the corporation had limited liability and a lot of protections, and so it was favored by certain types of businesses, and partnerships had a tremendous amount of flexibility but no protection from liability, and so people were forced to make a choice between which way they were going to do until the LLC was invented, which is essentially a partnership with limited liability and other protections that traditionally were enjoyed by corporations. The problem they have right now is that the law is divided into charity and business. And for the last 40 years or so, the whole regulatory system has been based on keeping these two things separate, and based on what is, in a sense, a cultural bias that says charity is about doing good and it's not about making money, it's about helping people. And if people who run charities are making money or anybody's benefiting from it, it's considered evil. And business, on the other hand, is about making money, and under traditional jurisprudence, businesses don't owe any social, don't have any social responsibility. Their responsibility is entirely to their shareholders. That's a little bit of an overstatement, and there have been various things over the years to try to mitigate some of this. But fundamentally, we still live in a world that is dichotomous. And what is interesting about social enterprise is that instead of a divergence of those two things, you have a convergence. So we now have an entire generation of people who are trying to do businesses that do good and do well at the same time. And unfortunately, the legal system is just out of whack with that. And so a large part of my practice and a lot of what we're all talking about, and I think a lot of what's going on here today, is how do you find ways to get those two objectives to coexist peacefully? And not just talking about corporate philanthropy or some of the things like that, but how do you actually run a company in a way that's oriented towards not just shareholders, a good profitable company, but where you're also thinking about your customers, you're thinking about the community, you're thinking about your employees, and you want to run your company in a way which is responsive to that. So what you see on the chart up there is that we sort of start from the point of these charities and these for-profits, and there are a lot of things that charities are doing these days to become more business-like and become more oriented, and some of them are listed up there. And there are a lot of things that for-profit companies are doing to be more philanthropic and more civic-minded. But the point of the chart is that those arrows don't meet. There is no continuum, that as companies become sort of more and more civic-minded, the analogy that I use is that the ice starts to thin, and at a certain point you hear this cracking noise, and shareholders get nervous, and boards get nervous, and their lawyers get nervous, and everybody gets nervous. So that you can go some way down the path, but you can't go as far down the path as social entrepreneurs would like to go. And the same thing for charities. A lot of charities have very significant commercial activities and operate only like businesses, not just small ones, but Children's TV Workshop and National Geographic and hospitals and universities that have very significant commercial activities. And yet fundamentally their board is got to be oriented towards mission, and the question is sort of, when does the tail begin to wag the dog? At what point do you say, well, you're really no longer a charity, now you're a commercial entity, you're really operating like a business? And the law in this area is really quite unclear. And so what a lot of practitioners in this area are focusing on now are these sort of so-called hybrids, where you use a kind of a combination of both. And I do a lot of this kind of work. So we're sort of left with three questions here, which is, as a charity, how far can you go before you run afoul? As a business, how far can you go before you run afoul? And then if you want to live in that middle space and have a hybrid, and have a nonprofit and a for-profit coexisting, and I've heard a number of people already today talk about how they have a business that's cooperating with a nonprofit or vice versa. How do you actually get those relationships to work, and how do you document them and make them work? So there are a couple of things. One is there is the emergence of these new legal forms. From my point of view, the Benefit Corp is by far the strongest and best of them. It's certainly not the only one, but it's being very widely adopted. It was very well designed and thought through, and I think that's, at least until something else comes along, that's probably what most people are looking at, because the Benefit Corp allows you to embed a social purpose into your organizational documents. And if you do that, the board of directors actually has an affirmative duty to pursue the social mission, which is roughly equal to its duty to deliver profits to shareholders. Having said that, there's not a single court case anywhere, there's nothing. So anybody who says they know the answer to any question like that is making it up. Nobody really knows, but we're beginning to get there. And as more and more states adopt this, and there's beginning to be an academic literature around it, some of these questions, I think, are going to begin to be answered, and some norms are going to begin to emerge. But by the same token, if I have a nonprofit client and they want to create a for-profit subsidiary to commercialize some product that they have, for example, universities are a really good example of this, because The model used to be that universities would do research and they would develop some idea, some invention that had commercial viability, and they would license it to private companies who would take it out into the marketplace and make a bunch of money. And the universities discovered that they were leaving a lot of money on the table because when they were just licensing the invention, it was unproven, they didn't have a good business model, and so they were essentially ending up selling it relatively cheap. And what most universities are now doing is they have business development units, and they actually start these companies and they bring them to market, and once they're able to prove the economic viability and the successful business model, then they can sell them to private industry and they make a lot more money. So here again you have non-profits, universities, the classic 501c3 that is now engaged deliberately in commercial enterprise, and how far can they go? Benefit corporations, for example, are a really good vehicle for those kinds of things because you can actually bake a social mission which is consistent with the mission of the charity in, and it gives some reassurance that although that's a business, it's also going to adhere to some extent to the mission of the charity. One of the big disadvantages of benefit corporations is that there are different flavors in different states. Some of them require benefit directors, some don't. Some of them require that you measure what you're doing against a third-party standard, some don't. Delaware just passed it, and they don't have the third-party standard in it. So it's very different, and people are actually rushing to Delaware to incorporate benefit corporations right now, partly because everybody loves Delaware, but partly because the compliance in Delaware is much less than it is in other states. And this sort of leaves open the question, well, what happens when the third-party standard, if you even have one, is developed by the American Petroleum Institute or something like that? So the fact that it's a benefit corp, which is in some senses intended to signal to the market that it's a different kind of company operating a different way, may or may not hold up depending upon how this stuff all plays out. So just a very brief thing about choice of form. I don't know how I'm doing here on time, but I'll try and do this very quickly because I know we have, Neil particularly, I want to see if he can talk a little bit about how you actually finance these companies and run them and capitalize them, because it's a very big, it's a very important thing. Is that generally speaking, what I tell my clients is you need to look at your capital and where it's coming from. Is it donated capital, for which there's no return invested? You're being financed by a foundation or by a philanthropist because they believe in the social value of what you're doing and they're not necessarily caring about a financial return? Or is it invested income, where you have profit-oriented investors who may love the social mission, but they're also wanting to make sure that they're going to get their money back, and that hopefully they can get a profit on top of that? If it's donated capital, that would argue in favor of using a nonprofit form as the vehicle for your venture. If it's invested capital, that would argue in favor of using a for-profit model for your venture. And the second thing is where your revenue is going to come from. If it's earned revenue from the sale of products or services in the marketplace, that's going to suggest a for-profit model is going to be the right model for you. If it's going to be donated revenue, and there are lots and lots of these models where, I mean, people are raising millions of dollars on Kickstarter, and nobody's getting a share of stock from any of that. The crowdfunding and the crowd raising has opened up entire new ways for companies to capitalize themselves, and they're not selling a single share of stock in return for all that capital. That may or may not suggest that a nonprofit is a better way to go, although plenty of for-profit companies are literally starting up using donated capital. And so it's a complicated decision, and for those that say, I'm not one or the other, I need both, and we see that a lot, that's where this middle space, which is the hybrid, is all about. The last thing I'll say about hybrids is that the biggest single issue right now in the law around hybrids has to do with control. The IRS has basically taken the position that where you have a small group of people who control both the for-profit and the non-profit, it's dead. It's not going to happen. You're not going to get tax-exempt status, because the presumption is that the small group of people who control are going to use that charity to benefit the business which is not allowed. You can go the other way, but they just presume that human nature is such that if they control both, they're going to use that charity to make money for themselves, and it doesn't matter how much you argue. So one of the things that you have to think about, and it adds a lot of complication, is having independent boards, having independent entities, arm's length transactions. There are a lot of formalities to deal with. You have conflicts of interest to deal with. You have private benefit. There's a whole long list, and if I had 2 hours, I could do the whole presentation. But I just want to flag for you the fact that although the concept is simple, the execution actually can be pretty complicated. So I'll stop there.
Great, thank you. And now Neil Jacobs.
Thank you, Dana. I'm Neil Jacobs. I'm the founder of N.I. Jacobs and Associates here in New York, and I'm also a 1983 graduate of Brooklyn Law School. So for those of you who are still students, I do remember the days when I was sitting on that side of the aisle rather than this side. My practice consists principally of corporate and transactional work relating to startups, technology companies, media companies, social ventures, and I spend a significant amount of my time on pro bono matters, principally related to bottom of the pyramid, market-oriented solutions in the developing world. So you put all that stuff together and you can see why I was thrilled that Jonathan asked me to be part of this panel today. First of all, I want to basically second everything that Alan just said. I think everything that he said is absolutely correct. Not simply because he spends most of his time doing this, but because I think what he has expressed to you is actually what I found and what other people I know who are active in the space have also found. The problem in a nutshell is that in terms of these new entities, there isn't really enough law out there in the sense of judicial decisions, state regulations, and so on, in order for us to be able to come to some sort of unified theory with respect to what a benefit corporation is. But I'd actually like to spend most of my time, if I may, talking about hybrids and about the corporate aspect of benefit corporations. And the reason for that is this. When we talk about hybrid structures, they usually involve a 501c3 nonprofit organization and a for-profit subsidiary, whether it's an ordinary corporation, an LLC, or some other type of business entity. And it's the ordinary business entity that actually goes out and raises funds, so to speak, not for the charitable mission, but rather for the corporate mission. And the point that I want to emphasize is that those entities are, in many respects, ordinary business entities. Yes, a benefit corporation is subject to a variety of self-imposed and extremely socially positive strictures, but it is still essentially, it's formed, for example, in New York under the New York Business Corporation law. If it's a limited liability company, it would be formed under, or a limited liability company that's a subsidiary of a non-for-profit corporation, it's formed under New York's Limited Liability Corporation statute. So when you approach the issues of capitalization and funding of these entities, you have to think basically in ordinary business corporation and LLC terms. And this is something that's very important. Now, for those of you who are out there who expect to either practice in this area or expect to actually launch a venture in this area, I would have a few takeaways. And takeaway number one is the same takeaway that I give to all of my clients who are launching in the for-profit space, and that is save your equity. Everyone thinks that if they get into business for themselves on an entrepreneurial basis and they start out with 100% ownership of a company, that 100% ownership of a company is something that they can effectively use in lieu of cash compensation. Well, no. You can use it in lieu of cash compensation, but you should not. You should be constantly keeping your eyes on the prize, which is the ultimate exit event, or in the case of a hybrid organization, creation of additional value for the nonprofit that sits at the top. So don't just give it away. Ask yourself each time that someone seeks equity from you whether or not they are really adding value to the pie. If the value that they're adding to the pie really makes the pie bigger, then they can take their equity and you'll have a smaller piece of a bigger pie. But if what they're doing is not really adding value and you're simply putting people on for purposes of window dressing, you're hurting nothing but yourself. And when you hurt nothing but yourself in the for-profit side, be it a benefit corporation, a wholly owned subsidiary in a hybrid situation, you're only going to end up hurting the social mission. So why are you bothering to do this? Keep in mind that you have to act in terms of governing that entity as if, in many respects, it were an ordinary corporate entity. Another point I would like to make is to place what we're talking about here into a different type of a context. We are talking specifically today about benefit corporations, about B-Lab certification, which in certain places is required for benefit corporation status, but others, in other situations, is not. Sometimes people will certify as benefit corporations for B-Labs, but not establish themselves as benefit corporations under state law for a variety of reasons, and these hybrid type enterprises that we are increasingly seeing. This is a fairly narrow slice, albeit growing slice, of the business world in general. I think that Holly's point at first, where she began to show numbers with respect to, or spoke about numbers with respect to socially oriented businesses and people who deploy their assets on a socially oriented basis, is significant and growing. But it's also growing into the for-profit sector. And what I mean by that is this, that if we talk about social entrepreneurship generally, we need to focus certainly upon these specific structures since they're the most common. But we also have to take a look at what's coming next. And what's coming next is the overall social and economic effect that these type of structures are beginning to have on the rest of the business community. There is significant additional buy-in by corporations of all sizes, shapes, and colors for social responsibility generally. Historically, corporate social responsibility, or CSR, was nonsense. It was a way of whitewashing, or as we call it these days, greenwashing, most companies' real lack of engagement in the social sphere. That isn't the case anymore. I'm speaking anecdotally, and Dana, you may have some data to back me up, but I'm increasingly finding, and it's one of the reasons why I'm heartened in a sense by what the folks at G-Labs are doing, that certainly in the smaller entrepreneurial venture space, even those entities that are specifically forming as for-profit entities do so with a social mission in mind. They do so with a significant degree of ecological consciousness. They do so with a significant degree of consciousness for fair trade and anti-child slavery issues. They do so with a variety of, with an awareness of a variety of other social issues that may end up impacting the way in which they do business. Now, even if they do not end up certifying as B corporations with B-Labs or any other alternative certifier, or whether or not they become benefit corporations per se, the effect of this entire movement should not be understated. It is, in my view, it is the direction in which business generally is headed. I think part of the reason for that is being driven by technology and transparency overall. I think companies recognize that if they are polluting in their own backyard, they're going to be found out. And they're not going to be able to greenwash themselves as saying, look at the 3 playgrounds that we built, when in reality they destroyed 3 communities nearby. The impact of the entire social business movement, I think, really needs to be kept in mind. Another point that was alluded to a little bit earlier, and I think Alan touched on it a little bit, is crowdfunding. And I'd like to talk about crowdfunding insofar as social ventures are concerned. At present, the only crowdfunding websites that are out there are non-equity crowdfunding websites. Kickstarter, Indiegogo, you can fund a particular project. You can pre-purchase, for example, a particular product that you think is going to be great. You'll provide the manufacturer essentially with the money to go ahead and manufacture the good, and you'll get the first line. Equity crowdfunding is still up in the air. The Securities and Exchange Commission issued proposed regulations about 30 days ago, I think. Has not become effective yet as to whether equity crowdfunding is going to be, or not whether it will be, but rather how it will actually function. My view is that equity crowdfunding is likely to be a disaster. It's not likely to have a tremendous impact either on the companies that are seeking equity crowdfunding or on the companies that are acting as the portals. I think it's unfortunately, and I'm very much in favor of entrepreneurship, as I think you can tell. Someone said that the Jobs Act, under which equity crowdfunding was permitted, should have been called the Jumpstart Our Bucket Shops Act. And I think that's what's going to happen. I think there's going to be significant fraudulent activity in the equity crowdfunding space. Having said that, that is not to say that crowdfunding would not make sense for a particular hybrid project. And I'd like to close, if I may, with a story or an illustration, because for many of you, the idea of what a hybrid is may not really be realistic or tangible. And I was talking to Alan beforehand about this. I had a situation recently in which a client came to me. They were a 501c3. They had started out as a 501c3 nonprofit organization for purposes. It was founded by a former Peace Corps volunteer who had done her Peace Corps time in West Africa. And she noticed that women in particular West African country were the great collectors of shea seeds, nuts, whatever they are, whatever shea butter is made from, and they would make this butter. But of course, they couldn't really sell it because they were isolated. There was no infrastructure. There was no business infrastructure. She decided to create co-ops and co-ops of co-ops in order to enable micro-entrepreneurs on the ground to be able to develop their capacity and to have a way of actually distributing their product. And lo and behold, she did that, and she actually purchased some of their product and started selling these shea butter products. Skin creams, soaps, lotions, and creams, and so on. She had very, very small activities. We're probably talking under $25,000 for several years, until such time as someone from the cosmetics industry happened upon her products at a trade show and said, "This stuff is unbelievably good. We need to put real money into this." And at that point, she approached me for creating a for-profit subsidiary and for creating the relationship between the nonprofit and the for-profit. It's exactly the sorts of issues that Alan had, in order to be able to take advantage of the sales of this effectively brand new high-end cosmetic product, which also at the same time functioned as the ability to service the community for which the 501c3 had been aimed, which is the women who are creating these co-ops in Mali. This story has a happy ending. About 2 months ago, there was a funding took place of the for-profit entity by an African Growth Fund that's led by Dick Parsons, formerly of Citibank and Time Warner AOL, and Ronald Lauder of Estee Lauder and Company. They put $750,000 into it. So again, this is what makes me optimistic about this entire area, not just in itself as a niche, but rather as a portent of things to come and as a way of shifting the paradigm of how business should be approached. Thank you.
Thank you. All of you gave us a lot to think about, and as someone who is, always sitting in my ivory tower thinking about these things, I have a whole bunch of questions. I'm just gonna start with one for each of you to get the ball rolling, and maybe there'll be a little bit more dialogue if we have enough time. I just want to make one clarification. I think in your comments, Neil, you mentioned the relationship between B Corp status and benefit corporation legislation, and not everyone maybe lives and breathes this quite so much as we do, and so I just want to make sure that folks understand. So, and Holly, please correct me if I'm wrong, so B Corp is a mark that you can license from B Lab, and any kind of organization, in fact it doesn't have to be a corporation, it can be a LLC or something else, and become B certified by going through their process and obtaining a certain score that shows on their terms, by their metrics, that you are the kind of company that deserves the mark. Benefit corporation status is a state-defined status available in, I guess now, 23 states, where there's enabling legislation in that jurisdiction to allow corporations to form, or reorganize as a benefit corporation, and in order to do so, they have to follow the requirements of the statute. Most, although importantly not Delaware's benefit corp statute, do require someone who is forming a benefit corporation to apply a third-party standard to judge that they are meeting a purpose beyond purely profit. That third-party standard could be the B Corporation status and obtaining the B mark from B Lab, but it could also be another third-party standard. And the applicant corporation applies that standard to themselves. They don't have to go to B Lab or any other certifier and be certified by the third party. They only need to use the third party's metric to judge themselves. Is that correct?
That's correct, and that's true for all states. You use the third-party standard as a rubric to create your own benefit report. Delaware is the only state that does not require the use of the third-party standard.
So very, very important to keep those ideas that sound similar, and obviously B Lab has been involved in both efforts, but to keep them separate because they do quite different things. So Holly, my follow-up question for you, I'm a really big fan of the B Mark product and the kind of private certification. I think that it can do good work, including the consciousness-raising work that Neil was talking about. My sense of the benefit corporation so far is that it's a fantastic legislative product, that legislators love it, and why wouldn't they, right? You go to the legislature, you say, you should enable businesses in the free market to solve social problems. It's something for the right, it's something for the left, kind of who could complain? Of course it's passing like wildfire across jurisdictions, but it doesn't seem to me like it's been so far penetrating as a really good product for organizations because they don't seem to be adopting it at a very fast clip. I know you've got some, big names, a few big names, but, even with, your count, you're under 1,000 entities in a couple of years with 20 some odd states. So do you think there's going to be, at some point this huge rush to the form, or is it more about consciousness raising than the form being really useful for entities?
I think that a lot of it has to do with consciousness raising. I mean, there are two of us that work on benefit corporations at B Lab, and there's only so much that we can do. So we go to as many of these types of events as possible. And after the legislation passes, we do a workshop if we're lucky in that state. And then we have an effective day event for the companies that incorporate. But I mean, that's about as much as we can actually do for that state. So I think that a lot of it is consciousness raising and getting the word out there. We're only as good as our contacts. And some states that we don't have that great contacts in. So I think it's just, a lot of it has to do with educating the public, educating lawyers, educating investors, educating businesses.
Alan, maybe you can come into this conversation now. I wonder if it's possible that the product, although it's identified the problem of this concern about having a dual mission and trying to embed it, if it really is solving the problem, just by adopting the form. Myself, I've been critical of the lack of enforcement included in the statute, either public enforcement or private enforcement, other than by shareholders. But Alan, it sounds like many of your clients are adopting a different model by using multiple organizations. Is part of that to create a kind of enforcement mechanism? If you set up a benefit corporation with a nonprofit, do you have more ability to control?
Well, if the benefit corporation is controlled by a 501c3, which is by definition operating for charitable and educational purposes, it is, for all intents and purposes, an asset of that C3, and therefore can only be used in ways that are consistent with tax exemption. But I think there are 2 points that need to be made here. One is that I think right now it's absolutely true that there's virtually no authority on benefit corporations, and so as lawyers we look, I mean, I do deals and I'm talking to people on the other side of the deals and I say benefit corp and they say what is that, and they look at the statute and it doesn't make sense to them and they're not comfortable with it, so they say to their clients, we don't know what this is, and uncertainty creates risk, and risk screws up the pricing of your deal, and so people tend to stay from it. But I think that's also a function of the fact that we are still in the infancy here. And I like to draw the analogy to the LLC, because the LLC was created in 1977 in Wyoming. It's a great story about how LLCs came to be. There were basically a bunch of legislatures in Wyoming that had a particular problem to solve, and they were trying to do business with a company in Texas, and Texas said, well, we want to come up to exploit some mineral rights, but we can't form a corporation in the state of Wyoming, and we're not willing to do a partnership because of the liability risk. And they literally sat around at about 4 o'clock in the morning after drinking a couple of bottles of Jack Daniels. They said, well, wait a minute, why don't we just create a partnership that has limited liability? And they just invented it and solved that particular problem. For 10 years, virtually no other state adopted an LLC statute until 1987, when the IRS gave a ruling as to whether this entity would be treated as a corporation or a partnership for tax purposes. Within a couple of years, I mean, LLCs now are everywhere because there was uncertainty. And until that uncertainty was resolved, people were too scared to move forward. And we don't have cases, and we're still very early, and the norms don't exist, but more and more people are learning about it. There are more and more examples of companies that are doing it and doing it successfully. There are going to be more and more stories of companies that are abusing it and using it as a, you know, for a sort of marketing device. Here's a gimmick, oh, we're a benefit corp, so we're a good corp, and they're going to go out there and really they're not. And again, you have to keep in mind what Dana said is extremely important, that the B Corp, which is a trademark, you have to go through an interview process, and you have to be certified, and you are then audited by B Lab based on that. My law firm is a B Corp, although we're not a corporation. And it was a real challenge for us to get certified because it's a pretty rigorous process. It was interesting because it forced us to look at a lot of our internal operations. So any of you that haven't done it, I actually suggest you go to the B Lab site and look at what the interview process is, and take that interview, because there's no obligation, and just see how you do. It'll really force you to think about internally how you're operating and challenge your assumptions. But the benefit corporation doesn't have anything like that. There is no real enforcement. But wait until we have the first shareholder action where some company says, well, yeah, our social purpose is to do X, Y, and Z, and they're doing, in most states, the company has to do a public report as to what it's doing to further its mission. In Delaware, the report only goes to the shareholders. But at some point, some shareholder is going to say, hey, wait a minute, you're not doing affordable housing, or you're not improving health care, or you're not developing economic opportunity in a disadvantaged area. And I invested in this company with the knowledge and the understanding and the promise that you were going to be doing that. And they're going to file a shareholders lawsuit. And if they win that lawsuit, that's going to change the whole game. Now, is that going to happen this year? Probably not. Next year? Probably not. But it's going to happen sometime, and we're going to start to get cases. I was up at Harvard yesterday at a thing about benefit corps that the B Lab founders were at, and the Chief Justice of the Supreme Court of the state of Delaware was there. The Delaware jurisprudence has always been totally hostile to any of this stuff. If you're a Delaware corporation, shareholder primacy is it. And they have a whole line of cases that say if you're a director of a business corporation, the only thing you're allowed to take into consideration when you run your company is maximizing return for shareholders. That's it. And that has been classic Delaware law for a long, long time. Delaware now all of a sudden introduces the benefit corp, and I was a skeptic, and I said, I guess they're doing it, but it runs contrary to the way the whole corporate jurisprudence has been in that state for 30 years. What does that mean? And the Chief Justice of the state Supreme Court got up and he said, this is a game changer. And the reason this is a game changer is because when you form a regular business corporation, the deal is that the corporation is formed to benefit the shareholders, and that's it. But when you deliberately put into your documents that there's another purpose to the corporation, and people invest in that company and they do business with the company knowing and with the expectation that that will be fulfilled, that the courts of this state are going to absolutely enforce that bargain, and we're going to stand behind it 100%. I was not expecting that. So when you start to see courts in Delaware, which is the forum for businesses in the United States, start to enforce some of these restrictions and give it some real teeth and meaning, that's all going to be a game changer. So we're all impatient and we'd like to see it happen tomorrow, but in the real world, it doesn't happen. I think what Neil said is absolutely right, which is this is a direction that business is going anyway. You see it everywhere. You see it in cause marketing, you see it in, Clorox with the green products and this and that. You see it everywhere. Companies want to be seen as good corporate citizens. And in my practice, among other things, I'm talking to a bunch of fairly mature companies that had been operated in this way long before there was ever such a thing as a benefit corp. And the founders of those companies are now looking and saying, how do I embed the legacy of the way I ran this company so that when I leave and the next generation of owners come, and I don't know who they're going to be, and they may or may not care about the same things that I care about, how can I embed those values into the company in a way that's going to stand the test of time? They all are talking about benefit corporations. So let's have the conversation in 2 or 3 years.
Dana, if
Yes,
I may, I just wanted to agree with what you and Emily said at the beginning about I don't mean this pejoratively, but the relative weakness, shall we say, of the benefit corporation statute as perhaps a little more than just a statutory phenomenon. And the question that you asked was, what will it take to get beyond the status quo? Is it a question of consciousness raising? And I think one of the questions that I had before I came here today, and I didn't have enough time to research the data, is to what extent do benefit corporations find it more difficult to find external funding simply because of the fact that they're benefit corporations? Picking up on one of Alan's points, if there is still some degree of uncertainty with respect to the structure, then that's going to affect the quality of the deal. And I think I'll give a rather glib but I think accurate answer. When the first benefit corporation does an IPO or sells out to Google or Facebook or something for an excess of 300 million, people will be banging on the doors of benefit corporations. Until then, I think it's going to be still a question of consciousness raising.
So I wonder, Neil, if I could ask you a question about financing, since you brought up financing. It seems like governance, what the benefit corporation is trying to do, is one way to solve this kind of problem of how do you embed a dual mission, how do you get the founders and the investors to come to some kind of enforceable agreement. But it seems like financial tools is another way to do that, at least for a relatively lengthy period. And it seems like in the startup area, like you said, be very careful in guarding your equity. Even outside of the social enterprise area, that's good advice. And for that reason, you see a lot of convertible debt in that space. And I've been working on with my co-author, Stephen Dean, who's also a BLS professor, and I hope the other person that Jonathan was alluding to earlier, on a lot of work on financial products that could try to embed that. And I wonder if you think that convertible debt is a good way to kind of create enforceable promises between parties who have both in mind a kind of dual mission but aren't necessarily ready to trust each other.
I think my answer is yes and no, more yes than no. Especially with startups in angel or seed stage, convertible debt is increasingly the way to go. For you lawyers out there who want to do startup work, guess what? You've just been disintermediated by Y Combinator. They've come up with convertible debt documents that work for about 80% of the standard angel or even perhaps seed stage investments. But having said that, I think convertible debt is a good way of doing it because within the context of that you can have all sorts of covenants, both positive and negative, that can be enforced. You could narrow, one of Alan's points is that the social mission of a benefit corporation can be, especially as, for example, in the New York statute, it can be extremely broad. And someone comes in and says, "I wanted economic justice," and someone else comes in and says, "No, I wanted housing," and someone else comes in and said, "No, I wanted environment." You can tailor the social mission that much more that way in the context of a convertible debt document. On the one hand, the no part is that the convertible debt will likely convert. The objective is for convertible debt to convert to equity at the subsequent round which presumably is the round at which someone perhaps more professional is going to be valuing the company. So the no part is A, there is going to be some level of dilution, and B, for those of you who are not familiar with convertible debt, what happens in a convertible debt situation usually is that you agree to lend the company money at a specific rate of interest and that it is convertible into equity either at a fixed rate then or more commonly now at the fixed rate of the next round of investment or a premium to that. In other words, if the next round comes in and values the company at $1 million, you get to convert at a 30% premium or a valuation of $1.3 million. The extra swing in the valuation on the convertible debt, I think, can be a real issue vis-a-vis equity. But otherwise, in general, I do think that that convertible debt could be extremely helpful as a financing tool.
Jonathan, do we have time for questions?
How are we doing? We're over time, but let's do a quick check. Our next caller is Skyping in, so I don't want to keep you waiting too long, but let's do a couple.
I was just curious to know what your views are on social impact bonds or the potential in that area. Can you say something about that?
This is to you or to whomever feels an expert. Neil, go ahead.
All right. There is, and Holly is well aware of this, there's an entire social investment vertical, for lack of a better word, of which social impact bonds are a part. There are venture funds that are B-Lab certified, like SJF, for example. I've never done any work on social impact bonds, I just know of them generally. I think that to the extent that these people can manage to, that this entire vertical can manage to produce good economic returns, people will ultimately be seduced by the ability to do well and do good. And that's my view of that, sort of that entire vertical.
It's really a brand new thing. It's very much like this. There have been very few bonds actually done in the US.
They're also not bonds. I mean,
not.
it's really
You're
just a
right.
marketing
Well,
term.
that's
it's
right.
a
They're
pay
not
for
bonds.
performance contract. It's
That's
really
right.
not. It's really a new, a new label on an old concept of pay for performance government contracting. But the idea is that the private sector is fronting some of the cost. That's
Right.
that's
So
the new.
the
tweak.
investors put up money. So let's say you have a nonprofit and they have a government contract that says if you can reduce literacy by 10%, we'll pay you $1 million, or whatever the metric is.
Increase literacy, probably.
Increase. Yes. Sorry. But the idea is that the government wants to pay for results. It doesn't want to pay for effort. And yet, it requires capital up front. So the government doesn't want to say, well, here, we'll give you the $1 million and hope you do something good with it. They say, we'll agree to pay you $1 million if you can achieve this result. And so private investors will come in and lend money secured by that promise to pay. And if the nonprofit can perform what it says it's going to perform, it then gets paid by the government and it repays its investors and it pays them a profit on their investment.
So our next speaker is Canadian, so that means he's very politely been waiting on Skype for us. I'm going to allow one very quick question beforehand, though.
Right. This will be quick. Neil and Alan, you both spoke about the nonprofit hybrids, like a church or a church or a museum having a gift shop or some other business which is definitely making profit for the nonprofit. If you could talk about the structure and taxation, National Geographic has a cruise business, etc. There are a bunch of these examples, and I'm sure I'm not the only person in the room who's always wondered about what's the structure and tax structure of these enterprises.
That's not a quick question.
Yeah, it's not a quick
I was
question.
thinking
Maybe you can follow up with them later.
The short answer is there's something called unrelated business income tax. So if the 501c3 is getting revenue from an activity which is doesn't substantially further its charitable mission in and of itself, that income is taxed at normal corporate tax rates.
Well, please join me in thanking our panel very much.
Thanks, Dana. Thanks, panelists. Great. We're going to now turn ourselves back to Skype. Is Joshua out there? Our next speaker, I've sort of been on the lecture circuit with him, I guess. We spoke both at the last Legal Hackathon, and we also both spoke at